Hello, everyone. Welcome to another episode of the Boardwalk Esquire podcast. Today we have Mr. Alex Settle here as our guest. He is the second in command over at the Atlantic County Public Defender's Office currently, and I'll let him talk a little bit more about his professional background.
Hey Lou, thanks for having me. My name's Alex Settle. I am the first assistant at the Atlantic County Public Defender's Office. Just a quick little background about me. Before becoming a public defender, I was previously a prosecutor. I was a prosecutor down at the Cape May County Prosecutor's Office for about 5 years. I ran the Gangs, Guns, Narcotics Task Force down there for a while. I tried a bunch of cases when I was there. And then I made the transition over to the Public Defender's Office. Really enjoy being here. It's a great job. Worked my way up to first assistant. It's my current role here. Um, One of the things I enjoy doing most is probably trying cases. I am a certified criminal trial attorney, like Lou here himself is as well. And Lou's tried a bunch of cases. But yeah, it's a little bit about me.
Gotcha. Yeah, and for the audience, me and Alex, when for those who don't know, I was also a prosecutor. Did that for 7 years, up in three in Burlington County and four in Atlantic. And when I was in Atlantic County, Alex was the assigned public defender that I had every one of my cases with, for the most part. And so we did that for a few years, and then I got moved to a different unit there, and then I opened my practice in 2024. So we both kind of had the same, track of doing a little bit on the prosecutor side and a little bit on the defense side. So Alex, let me ask you, and I'll chime in too. Like I guess just talk about that transition. Like for you, like was it a difficult transition? Was it something that you always knew you were going to do? Like, well, tell me a little bit about that, going from the prosecutor's office, to the public defender's office.
So for me, I think it was actually a pretty easy transition. Before I had even gotten to the prosecutor's office, I was actually in private practice for a little bit. I had worked for a local attorney, and then I went out on my own. I did pool cases for the public defender's office, and for those that aren't aware, pool cases are conflict cases. So at the public defender's office, if there's a conflict, that case is then pulled out to a panel of attorneys that we have to handle those cases that are on a conflict. So I did conflict cases for the public defender's office, and I did that for a little while, basically until a spot opened up at the prosecutor's office. And then once a spot opened up, I went there. One of the main goals that I had was to try as many cases as I possibly could when I was there, and had this set thing in my mind that I would spend a number of years there and then I would go back to defense work. And that's what I ended up doing. So for me, I felt like it was a pretty seamless transition. I was pretty aggressive when I was a prosecutor. As you
Yeah, some
remember,
would
Lou
say.
was a
Some would say.
Lou was a law clerk when I was a prosecutor down in Cape May, so he got to see me. And I think most people would agree that I'm just as more aggressive, if not more aggressive, on the defense side. And I think Lou could probably attest to that, considering we were matched up as a pair for a prosecutor and a defense attorney for a while in the Atlantic County courtroom.
Yeah, there was, looking back on that, I used to think some of these guys would come in and they would hire, someone to represent them. And I used to think to myself, like, they should have just stayed with Alex because they just spent money
Appreciate it.
to have someone do, essentially less work on their file. But yeah, I mean, Alex, I've known Alex now for, going on about at least about 10 years. And, he was always aggressive in every role he was in. Um, do you like, how do you like, what did you enjoy doing more? Defense work
Well,
or prosecution work?
I get asked this question a lot, and my answer is always the same. It's always defense work, and the example that I give most of the time is the feeling that you get as a prosecutor when you keep somebody in jail that you truly believe deserves to be there pales in comparison to the feeling that you get as a defense attorney when you get somebody out of jail that you truly believe doesn't deserve to be there. It's just it's a completely different feeling. And I also like defense work more because I feel like, you know, the idea of making a difference and, helping people. And sure, I got to do that as a prosecutor. I if breaks were warranted, I was able to cut breaks. I was able to give consideration to the whole person. But I feel like I'm able to do more on the defense side, especially as I, continue to hone my skills and I continue to educate myself and develop. And that's one of the things is it's about being an attorney is you can never just stop and be complacent. You're always going to have to continue to learn. You're going to have to continue to keep up with the evolving case law and the evolving technology too, in terms of how to leverage your time. And we've talked about this before, some of the AI tools that you use, like Westlaw, to help present a better defense on behalf of your clients. But I'll put it back on you. I mean, what did you enjoy more, Lou?
I, I definitely enjoyed doing defense work more. I mean, I enjoyed being a prosecutor too. I did it for 7 years. Um, I, I always enjoyed dealing with members of the public. So, cases where there was a victim, I always tried to, involve them. And a lot of times, and like a lot of times they're not involved. You'll have you'll have a crime, even some of the more serious crimes. Like sometimes the victims, they didn't care, they didn't want to be involved. But I always made sure that I at least had someone reach out to them because sometimes, sometimes they wouldn't even fill out police wouldn't fill out the victim notification form. And there wouldn't even have been there's not even like a contact from the office. So I always made sure there was that, and they had an opportunity to be involved. But very few cases where was there consistent involvement with the victims. And so, to me, after 7 years of kind of just having cases that are just faceless in a way, it is a bit of a grind, and you don't really feel like you're doing a whole lot except just filling a slot that anyone else can be shoved into. Um, so I definitely felt that way. I mean, but I agree with you. Like, I helped people when I was prosecutor, and it was the victims. Like, if I had a victim crime and the victim was involved, I always made sure, like, what they wanted to see happen was one of my top priorities, within reason. And then, like for the cases, like the one thing I miss as a prosecutor is, you get to decide what happens with the case for the most part, within reason again, because you got to get approval from your superiors sometimes. But, you know, going from prosecutor to defense, I definitely miss that part. Do you miss that part?
Yeah, I mean, it's interesting what you're saying. I mean, that is what I did as well, making sure you consult with the victims and keeping them informed. And I got to say, that's not always the case with every prosecutor. And I'll never forget when I was in private practice the first time around, and I had for the first time a victim hire me, just basically because they wanted their voice to be heard and they wanted to make
Yeah.
sure that there was communication with the prosecutor in terms of getting their wants and needs across because they felt like that wasn't happening. They felt like they didn't have a voice. And it was an odd feeling because I had never had somebody that was a victim in a case hire me before. And I had to explain, like, I'm not really sure what I could do for you other than keep in contact with the prosecutor's office and just, advocate your position. And that's all she wanted.
Yeah.
And sometimes I don't always get that. But yeah, I agree with you that that's probably one of the most important things. And now on the defense side, we're doing a different type of advocacy. Now it's advocating for our clients and making sure we can get their points across and their desires and their wishes. And, you know, I think it all comes down to advocacy. Advocacy is pretty much everything that we do. We advocate to the prosecutor in terms of why we think that a certain sentence is warranted. We advocate to the judge why we think a sentence was warranted, and we can advocate on behalf of the client for a multitude of different reasons. It could be um, mitigating information that they have as far as things that they've gone through in their childhood, or a drug dependency, or a mental health issue, things like that, and that's what we do. We help support them,
Yeah.
we help advocate them, and we help try to get them on the right path.
And there's, like the harken back to going from prosecutor to defense work. I'm still friends with a lot of people that I worked with, obviously, and some of them look at me and they're like, "Hey, how do you go from one thing to the next?" I guess for me and for you, we're not married to one side or the other. We're really like married to the process and the advocacy with the, regardless of who we're representing. But would you agree? I think there's certain people who are either true believers on the prosecutor side and they could never do anything else, and or true believers on the defense side and they can never do anything else.
I agree. I mean, I think it's like that on both sides. And when I go back to this, I'm still friends with a lot of the prosecutors. I'm friends with prosecutors down in Cape May where I worked, and I'm friends with prosecutors in Atlantic County who I've had cases with. And just talking to some people, whether they be prosecutors or whether they be the general public, you do often get those remarks like, how can you do that? Like, how can you
Yeah,
represent these people? Like, how could you sleep at night? All right. And what I explained to
right.
them is like,
Like,
I'm not like defense attorneys are not like pro crime. We're not rooting for people to go out there and commit crimes. Like, yes, I'd be very upset if my house was broken into and, ransacked and something was stolen. But I'd be even more upset if the police didn't play by the rules and it resulted in evidence getting suppressed and then that person not ultimately being held accountable for what they did. And that's what we're there for as defense attorneys, right? Like we just make sure that everybody played by the rules. Like,
yeah,
were you supposed to obtain a search warrant? Did you obtain the search warrant? Okay, if you did and you obtained the evidence lawfully, then the evidence is going to come in. If you didn't, then the consequence is it's going to be suppressed. And I think that's what we serve as, checks and balances. So did you do things right? Did you dot your I's? Did you cross your T's? Did you follow all of the rules? And if you followed all of the rules, then unfortunately, the person that committed the crime is going to have to be held accountable. And then it's just a question of what do we do from there? What is the ultimate resolution going to be? What's the sentence going to be from them? Is there any types of mitigating information that we can provide to explain why they committed this crime? Did they steal something and pawn it because they're drug dependent? Did they damage somebody's property because they were in the middle of a mental health episode? These are all explanations that go from there once we've made sure that the police and the state have done everything that they were supposed to do correctly.
yeah, and like going from prosecutor to defense, I definitely feel more of a weight of responsibility because it stops at me. Like you work for a prosecutor's office, it's like, all right, you're a cog in the machine over there, right? Like they have so many more resources. Like if they need an investigation done, they call their detective and they send them out there. Me, most of my private cases, the client has to pay for an investigator. So you're as the defense attorney, the buck stops with you. Like if you don't do a good job, then no one else is. You're the only person on your client's side. So like I take that super seriously. Like I like you said, like you want to do everything you can to make sure that they have a fair process. And because if you don't, then the other side is always pushing the boundaries. The state's always pushing the boundaries. They're always trying to push the limits of what they can do, and that's I think a natural process in the adversarial system. But if you don't have that pushback from the other side, then you end up with really disproportionate outcomes, and pushing the law to an illogical limit in some cases. I think.
Yeah.
Does that resonate for you?
Yeah, and also with regard to the state, what I also explain is that the state basically has unlimited resources, right? Like they have unlimited investigators, they have unlimited technology. And that's why it makes it all the more important the job that a defense attorney does, the ability to really dig into the file and to really make sure that things were done correctly. And I agree with you. I take it very serious. I do the best that I possibly can for all of my clients. I do a thorough job. I review everything. I identify weaknesses. I exploit them if possible, and I try to get them the best result possible. And people have asked me, because a lot of people, their biggest fear is speaking in front of a room full of people, right? Like most people are say, how can you stand up in front of a jury and talk to people? Like, aren't you nervous when that happens? And sure, there's the general nerves that go along with that in terms of getting up and standing in front of a room full of people, but that's not when I'm the most nervous. The most nervous is after I sit down and my closing's over and the jury gets charged and they're out and I'm waiting. I mean, that is when I'm the most nervous because at that point in time, it's out of my hands. There's nothing else that I can do. At least during a trial, I have the ability to do an opening statement, and I have the ability to rebut things that the prosecutor has said. During cross-examination, I have the ability to attack the witnesses. I have the ability to get my story out through them, whatever the story that we're telling on behalf of the client. And in my closing, I have the ability to convey that to the jury. But once I sit down, once that jury is charged, it's out of my hands. And that's probably when I'm the most nervous. And then I could tell the nerves creep in as soon as the jury comes back with a verdict. And I think that's probably the most anxious that I am ever in this profession is when the verdict is about to be read, and then until we get the ultimate result of whatever it is.
Yeah. No, and you kind of like, at least for me, like I had a trial the other day, and it was a case where like I read it. It's like I should win this. Like there's serious issues in this case, and you're going in there, and I'm thinking to myself, man, like this woman's future is in my hands. Like because if something goes wrong, it's going to have a devastating impact on her. So and you don't feel the same. I mean, I felt it as a prosecutor, maybe when I had the homicides that I handled. I mean that those had obviously like very serious. You felt the weight in those ones because those cases, the victim's family was obviously almost always involved, and there was a lot at stake there. But other than that, like I didn't never really, you don't feel the same way. I didn't feel the same weight on my shoulders like handling a lot of these other cases as you do when you're sitting there as a defense attorney on any particular criminal case. There's massive consequences. Like even if the outcome is going to be probation, you get convicted, you lose your job, you lose a career, you lose a professional license. It's like your life isn't the same ever again. And I think to me, especially when I was a prosecutor, I tried to be fair, and I tried to really think about those like sort of ancillary consequences. Um, and I think too some of these more serious crimes, and we could talk about a few of them, but like there's what you envision that crime like like covering, and then there's like what it's being applied to, like certain circumstances it's being applied to, and I want to talk more about that in a second, but um, like it's just there's so much more weight as a defense attorney, and weight of responsibility, and I at least I feel it, and I think if you don't feel that weight, like like maybe you're not doing the right profession.
And
This, you know what I
I
mean?
agree. I mean, there's a tremendous amount of more weight being a defense attorney than there is being a prosecutor. I mean, as a prosecutor, you present your case, you do what you're supposed to do, and at the end of the day, if the verdict is against you, in favor of the defense, that is what it is, right? Like you do what you're supposed to do. Like there really shouldn't be any weight there, right? Like there's no additional consequences. Like okay, they found the defendant not guilty. Move on to the next case. There, I don't understand why
Right.
you would perseverate over it or be upset
Yeah.
about it,
Yeah.
right? Like for the most part. But as a defense attorney, no matter what, like, yeah, that is a weight that is hanging over your head because at the end of the day, you know the consequences for your client. And even if somebody doesn't have a record, there's still collateral consequences that come along with a felony conviction, right?
Right.
Like they get convicted of a felony, they might get put on probation, but they also might lose their job. They might lose their housing. They might not be eligible for certain benefits anymore. Like there is a significant number of collateral consequences that go along with that, as opposed to just jail time. I mean, jail time and prison time, yeah, that's real as well because you're incarcerated. You're away from your family. You're not able to provide for them. Those
Yeah, and
are those are real consequences too.
you really see that more. Like as a prosecutor, you just you don't talk to you don't talk to the other side. Like, and especially if the municipal prosecutors do. So if you're a municipal prosecutor, you have to deal with the defendants and actually talk to them. And I think that's it's a really different world having to do that. Because you kind of see what the other side sees or interacts with or deals with, and as a county prosecutor in Superior Court, you never talk to the defendants. Like you don't talk to their families. You don't interact with them at all. And you know, obviously you do as a defense attorney, and like you see the collateral consequences of like, well, here's the client's girlfriend or wife who has two kids with him, and they're barely making rent, and he's in jail, and like, you know, you feel the weight of that because like they make it very clear. It's like, if he goes away for, I can't survive without him. Like, if he goes away for X number of years, like I'm gonna lose my apartment, or like I'm not gonna have child support anymore. And that's real. It's a real impact, And then you have these kids that are growing up without a father, without financial stability, and it ripples. And I'm not here to make any sort of political argument, but like on a case by case, like I see it all the time, and
Yeah.
I just wish sometimes I wish the prosecutor was able to experience that as well and have a little more perspective on that, because I do think that some of them are a little just sort of like they're just emotionally cut off from it, whether it's purposefully or just simply by way of the fact that they don't have to deal with it. They don't have to see it. They don't interact with that. They just kind of see, this is the defendant, I have his rap sheet, and I know what he's charged with, and that, like, I don't, the rest of it is,
Yeah, and it's
I'm
true. And
going.
unless you can, see behind the curtain and look to the future and see what is going to be the ultimate outcome and what the impacts and the lasting impacts are going to be, you may not have a perspective on it. And like what I always, start with and take into consideration is like detention hearings, for example. My personal opinion with detention hearings is that if there is a remote possibility that that person could get probation or could get something that is non-custodial, put them on a warrant, but agree to release conditions to at least give them the opportunity to report because of the collateral consequences that are going to occur from them being in jail even for a few days. Like even if we get to the point where they have their detention hearing and the judge agrees to release them on conditions, um, they may have lost their job by that point.
Right.
2, 3, 4, 5, 6 days, that's it. They've lost their job. They're no longer able to provide rent. Like, especially with some of these cases where somebody is a 1-1 with a release recommendation with no prior criminal history, and they're charged with a DP simple assault. Like, that person in no realm is going to get any form of incarceration for their first offense. It's just not going to happen. They're going to get probation as a worst case scenario. If I was still at the prosecutor's office, I wouldn't be filing on those people just because they're
Yeah.
not only in that case is there a possibility that they're going to get probation or a non-custodial resolution. There's a very high likelihood, and I think about the collateral consequences that'll occur if that person is incarcerated and detained even for a few days, where they could lose their job and then they're no longer able to keep a roof over the head for their family. And I think probably being on the defense side has allowed me to experience and see those collateral consequences a little bit more and have a lot more empathy for our clients.
Yeah, and then just for the audience who might not know the process in New Jersey. New Jersey doesn't have monetary bail in a general sense. If you're charged with a crime, depending on what it is, the state can file a motion to detain you, and then a judge decides whether you stay in jail until the case is resolved. And so, that detention hearing, in a lot of cases, is basically like decides the fate of the whole case, because if you get detained on a low level offense, and even if it's an offense where they might not be able to necessarily prove it in front of a jury, you're sitting in jail while it's pending. And if you don't have a record and the offer is like Alex said, something that's like probationary, you end up in a position where, well, I can go to trial and it'll be X number of months away, or I could get out today and plead to this, whatever the offer is. And that's what often happens in cases where you have a detention that's been granted. So, and to your point, Alex, I just had, they ended up, resolving the situation without me, but I had someone call me, and they got detained. It was the victim who called me. It was the boyfriend. He had filed a restraining order against his girlfriend, and she violated it. She went to the house, and they were talking, and and she left, and she got charged on that case, and the state moved to detain her. And now you're talking about a misdemeanor. She had no record. It was just one misdemeanor, violated restraining order. In the meantime, he actually dropped the restraining order and didn't want to move forward with it. And then she got detained on the restraining order violation on a misdemeanor, which, that would have, if she was on the street and came to court, like the first court appearance, she would have been offered like a petty misdemeanor harassment for like $100 fine. And instead she sat in jail. And to give some perspective here, if this is on a second violation of a restraining order, a second one, not a first, the second one, the mandatory minimum is 30 days in jail. Okay. On a first, there's no mandatory minimum and it's a misdemeanor. So you have no record. You're not looking at, like, you're not getting jail. You're just not. So she's
Yeah.
detained on that, right? And in order for it to be heard in family court, the prosecutor's office has to file the paperwork to send it back down to that court. But they didn't do it. It took them a couple weeks to get it done. So this woman's sitting in jail over 30 days, which is the minimum on a second offense. She's there on a first. The husband's or the boyfriend's like the one calling, like trying to get her out, because he's dropped the restraining order. And here she gets detained on that case, and she sat probably a good 6 weeks before they finally got her in front of the judge. And the first court appearance she resolves to a harassment, right? And so, it is you like people. I just, I think a lot of people, they have kind of this notion of what the criminal justice process is like, and they don't see the bullshit that we've seen. Like they don't see like when like nonsense like that happens, and it's like, what are we doing? Why are we like? And meanwhile, I think she lost her job. Like, it just upended their lives. Um, but yeah, like the detention process can be just very, very, I think, unfair because it's just so subjective as well. Going from you flip a coin. Which judge is going to decide the detention? Like which court's going to hear that detention hearing? And it just varies dramatically as to how different courts will handle different defendants and charges. So you end up with a very unpredictable. You get two cases that are exactly the same. You put them on 2 different days, and you could end up with 2 different results. And that's the kind of stuff that bothers me. And I think it would bother the average person too, but they don't have, it's not part of their life. They don't see it, so to them, when they don't have the same perspective as far as like doing this for years, it doesn't impact them the same way. Is that?
Well, yeah, and going back to the average person, just going over what you said, what I do with the average person is I say, imagine a situation in where you were just taken and you were put into the county jail. And for 6 weeks, you sat there. So for 6 weeks, you didn't have access to anything. You couldn't log in to your bank account to pay your mortgage. You couldn't
Like,
log into your bank account to pay your credit card or your utility bills, your rent if you were renting. You had no access to any of that. You didn't have the ability to call your employer to tell your employer, when you were going to be back at work or if you were going to be back at work, because at that point you don't know, right? Like you don't know if you're going to be back the next week or the week after. And how long can your employer really keep your job open for, right? With you just not showing up. And that's if you're able to get through to a family member who's then able to call your employer, who's able to explain to your employer the reason that you're not there. Otherwise, they may just think you're a no show. And a couple no shows later, you're fired. What would your life look like for 6 weeks if you were cut off completely from the outside world? You had no access. What would happen? Like play out day by day in terms of how things would go. The first comes around, your mortgage is due, your rent's due. How's that getting paid? Right? You're not getting a paycheck from the bank. What happens if that direct deposit isn't deposited? And then your bank account overdraws, right? And then you're getting hit with fees from the bank. And then eventually you do resolve your case and you've got to pay fines on it, right? And how are you going to pay those fines? Because you lost your job and now your account's in the negative. Like it is a snowball effect that occurs from clients of ours that end up getting incarcerated and sitting in jail. And I think the most frustrating part is for cases where they realistically shouldn't be incarcerated or sitting in jail when the ultimate resolution is going to be some sort of fine or some sort of probation. It's just a really unjust result because it's not just that they're sitting in jail. There's a number of different collateral consequences that are going to come along with that. And then you think about that's just financial, right?
Yeah.
What about family aspects? What about if you have a child, right? How are you going to get that child to daycare or pick them up from daycare or get them to school or pick them up from school? Who's going to put them to bed at night? What happens if you don't have somebody else in your life and that person has to go into DCP&P custody for the time being and they have to be placed in foster care for a period of time because they don't know when you're going to go out of jail? Like these are the real consequences that people have to think about because these are the impacts on people's lives that you're going to have just by a decision in terms of whether you're going to file to detain somebody and whether you are ultimately going to detain that person. And what I
Yeah.
always go back to is if there's a possibility, even a remote possibility that that person is not going to get state prison, they should be released. Give them the opportunity to be on pretrial release. And then if they violate that opportunity, then you address the consequences then, right? Then they can file motions to revoke release and, incarcerate them or increase the level of reporting that they have to provide by. But, I've always been of the mindset if there's even somewhat of a remote possibility that this person is not going to state prison, that they should be afforded the opportunity on release just because of all the consequences that come along with it.
Yeah, and on a different note, but towards the same topic is, and I think what that area it bothers me, given just the sort of randomness at times of it. Um, the other thing that it bothers me going from prosecutor to defense is there's such a wide difference between charging someone and proving the case beyond reasonable doubt, and that's where the discretion of the prosecutor's office lives. Like because they
Yeah.
only need they only need probable cause to charge you. Which for anyone who is watching this that doesn't know what that exactly means, it just means that there has to be a well-grounded suspicion. So there's a I'll give it a great example that comes up all the time. Guy gets pulled over. He's got four people in the car. One thing leads to the next, and the police end up searching the car and they find a gun in the car, and it's in the center console, in the middle of the vehicle, and nobody says it's theirs. Everyone in that car is getting charged with possession of a gun, okay? Because there's a well-grounded suspicion that one of them may have possessed the gun, or they jointly possess the gun. Now, in reality, though, in a trial setting, it's pretty difficult to prove that the backseat passenger who doesn't own the car and wasn't driving knew about this gun in the closed space of the center console, right? Difficult case to prove. A lot of times you probably can't prove it because you really have no other evidence other than the fact that they're in the vehicle, right? Um,
Yeah.
and so, but, if anyone in that vehicle has any type of record at all, like if they have a prior record at all, and they get arrested on that gun, because they're going to put that on a warrant and they're going to try to
Yeah.
file the detain. Almost every single case, you get a car of four people and there's a gun in the center console. Everyone's getting put on a warrant. They're going to file a motion to detain, and then if you have a record, even if you're the backseat passenger and it's like not very clear that that's your gun at all, there's a good chance you might get detained. And so to me, like I wish there was a little more exercising of discretion in these situations to be like, okay, you know, let's not file a detain on this person because, hey, let's be realistic here. The driver is the owner of the car, and it's probably his gun. But there's just too much of like, well, we're just gonna throw a wide net. Whatever happens, that like, if they get detained, great. If they don't, like, who cares? Like that's sort of the attitude in those situations. And then you end up like I had a couple of clients where they're just a passenger in the vehicle, and if they weren't detained, we would just be sitting around waiting. I'd be like, we're not doing anything. Let's see what this driver does because he's the guy they have the most evidence against. But then they get detained, and I'm sitting there, and I have a client who's detained, and like I had one where I knew I could probably get him probation, and I ultimately did. And I still said to him, I was like, look, I don't think they can prove that this gun belonged to you, but like if you can either go to trial and we'll litigate motion practice, and it could take up to 6 to 12 months minimum, or here's probation. You could take probation. You'll be out today. And it's
Yeah.
left with that
And
choice.
unfortunately, that's what we tried to do. We tried to get away from when we had criminal justice reform, because the concern before when we had bail is people that were being held on monetary bail that just couldn't afford bail and ended up pleading guilty just because they wanted to get out of jail. And now we have a risk assessment system, which, you know, again, it depends on who the prosecutor is that reviews it and files it, and who the judge is that ultimately ends up hearing it, whether that person's going to be released or not. But what I always go back to is, if, for the example that you gave, the four people in a car, if you want them on warrants because you want them on some sort of supervision, then put them on warrants and agree to release conditions. And then if they violate, you can revoke the release and pull them back in,
Yeah,
versus the collateral consequences that are going to flow, whether they get released at the detention hearing or not. If they get released, they still have some collateral consequences after sitting there for a week. They may have already lost their jobs. And if they get detained longer than that, then they've definitely lost their jobs and likely lost their housing and everything that's gone with it.
yeah,
That's just
yeah.
an unfortunate reality of it.
And I'm not saying this is done all the time, but I've seen it in certain cases where, hey, this first degree crime here doesn't really fit the facts, but there's probable cause, and if we charge it, there's a greater chance they're going to get detained. So let's throw that first degree crime in there, and it'll help us in the beginning of the case. And hey, well, it'll go to the jury, and the jury will probably find him not guilty, but that'll be leverage for us later on. And look, like when I was a prosecutor, to some extent, I'm sure I did do that as well, but I've seen it like really to the point of being abused, like adding some of these charges just to impact the PSA, the public safety assessment, which for anyone watching is a document generated before the detention hearing by the court, which is just a summary of someone's court history, their charges, and it gives them a score. And then the score will then recommend whether you should be detained or not, and the judge can decide whether to file that recommendation. But it's heavily persuasive, and if you're charged with a first degree, it will increase your score, and it will potentially increase your recommendation from release to detain. So, I've seen that too, where
I agree with you. And I've seen it too. And the classic example that I see that it's used, and I would say misused, which is really a shame, is like, I'll give you an example. Somebody that may have been, 18, 19, 20 years old, that was convicted of a third degree possession with the intent to distribute. And now later in their life, they're stopped in a motor vehicle, and it's them and another person, and they search the motor vehicle and they find drugs, whether it's, second degree weight or third degree weight, and they find some packaging material with it. Now,
yeah,
normally it would just be a third degree possession with the intent to distribute, or a second degree possession with the intent to distribute, and drug paraphernalia. But we're seeing an increase in people being charged with the first degree manufacturing facility, even though that there is no information that supports that there was continuity of use, or that that vehicle was ever even used to package or assemble or manufacture narcotics. But that's charged because then there is leverage. If they're charged with a first degree and there's a prior third degree possession with the intent to distribute, even if it's 5, 10, 15 years ago, they're then extended term as a repeat drug distributor, which then shifts the balance, right? Now, there it shifts to the defense to rebut the presumption of detention, because that person is facing the possibility of a life sentence. Now, at trial, they'll never be able to prove that first degree manufacturing. And what it
yeah,
also does is it renders that person ineligible for a lot of programs. They're no longer eligible for recovery court, mental health court, APO, any of these other types of diversionary programs that they would normally be eligible for on a second or third degree crime. They're no longer eligible for, because they have that first degree manufacturing that's hanging over their head. But it's a charge that's a non-provable charge.
yeah.
And
No,
then and
I
and I
agree. that charge is one of the primary charges I've seen like sort of abused in the initial charging decisions and applied to situations that in my entire career. And this is like I've never, I may, if I felt I could prove a charge, I would put it in there. Um, like even if it would have been difficult, perhaps, but I would never put a charge in there that I thought like was never going to be provable. And I've seen like them. I've seen that charge added so many times where it's like there's no it's a this is like it's just a regular car stop and you found drugs in the car, and in like 90,000 other cases it's a third degree distribution, but you decided that this needed to be a first degree manufacturing facility. What was the difference between this one and the 90,000 other cases where the same situation happens? And that statute is poorly worded. It's overly broad in the way it describes what it applies to. And that's the other problem is you have the legislature who says we want to make this thing illegal and punished more, right? And then there's what they intend to apply things to from like a common sense layperson perspective, right? Versus, okay, well, this is the law we drew up, and now you have lawyers on the state side saying, well, how creative can we get with this language? And I see it a lot too with that the first degree home invasion they just passed earlier this year,
Oh, I
where
know.
you know back to the same thing where it's like I used to use the example. It's like being a prosecutor isn't like taking a law school exam. In law school, if you were in criminal law, you would have a fact pattern, and it would be like, tell me all the crimes that apply in this fact pattern, right? And then and argue it out, right? And you would sit there and you would write out, oh, this can be this and this can be that. Like charging someone with crimes in New Jersey shouldn't be like a law school exam where it's like, how many crimes can we jam into this fact pattern? And that's what it feels
Yeah.
like sometimes. Um, you know, it's like, hey, like just because you can maybe like argue that the elements as written in the statute apply here, it doesn't mean that you should charge that crime in this situation because it's just not warranted. Like having someone where like the first degree home invasion, I saw one where it was like a neighbor dispute. The neighbor is at the doorway of the other neighbor's house and they're arguing with each other, and the one neighbor punches the neighbor who's standing in his doorway. And because his hand crossed the threshold of the doorway and struck the other person, it went from a misdemeanor assault to a first degree home invasion. And it's like,
Yeah.
when they passed that law, did anyone in the legislature imagine like, oh yeah, this is what we're trying to punish, the old neighborhood dispute with one punch? Like, is that really what they're looking to punish with that? But here we are.
I,
Like,
I
here
I
we
agree with you. I mean, I saw a similar one not that long ago where there was an argument between two women. They were standing outside on the porch. They started pushing and shoving each other. It ended up resulting in them getting tackled and going to the ground. They fell into the door threshold at the time. They got broken up, separated. They both went their separate ways, and the woman whose house it wasn't was charged with the first degree home invasion, which it's not. I mean, like, if they didn't fall into the doorway, this is a disorderly person simple assault all day. They're never getting charged with more than that.
Exactly.
And likely what happens is they're both not going to prosecute against each other, and that case is getting dismissed. But here in this situation, it's a first degree. They're going to file for detention, and then we have to see what happens from there. It
Yeah.
depends. Do they have a prior criminal history, years ago, that's going to shift the presumption, and then that person's facing a life sentence where there's a presumption of detention, and then they get detained and they sit there until the case gets resolved? Do they have no prior criminal history where
Yeah.
they're going to get released, but ultimately they're going to be facing a NERA offer, and maybe they agree to take probation because they're not eligible for PTI because it's a first
Yeah.
degree crime, and they're not going to amend it for them to become eligible? Like, yes, that wasn't the original intention of the legislature. The original intention is the typical first degree home invasion that you see, where a family is sleeping at night and a masked man breaks in with a gun and holds them up at
Right,
gunpoint and takes
right.
everything in their
Like,
house. Like that is
that's
your
what they're
typical
aiming
first
for.
degree home invasion that is contemplated by the legislature. But just because of the broadness of the statute, we have it being applied in circumstances that I think necessarily don't warrant it.
And for those of you who are watching this and may be thinking, well, the legislature, like they know how to write laws. They know what they're doing. Like they wrote it that way because they wanted people to interpret it as broadly as possible. Like for those of you thinking that and thinking maybe like, wow, they have lawyers who work in the legislature. They must have been, talked to. They must have been part of that process. Uh, Recently, they passed a law adding a new mitigating factor for sentencing to so that courts can consider a defendant's domestic violence history as a victim. Because a lot of our clients, unfortunately, they were victims of domestic violence as children, and so they passed the law so that courts can consider that. But when they passed it, they accidentally removed a section of the law that allows a court to sentence someone 1 degree lower under extraordinary circumstances. Um, so if it was a first degree, normally that's 10 to 20 years. Under that section, they could sentence someone to 5 to 10 years if there's enough mitigating circumstances. Well, they accidentally removed that entire section because they didn't they signed the wrong version of the bill. So now everyone's scrambling because they removed this section, and we're hoping that, from what I heard, they're working on fixing it. I don't know if you've heard. Are they? Is there any
Yeah,
confirmation
they're
on
from
that?
what I've heard, they're currently working on fixing it because apparently everyone is in agreement that that should not have been removed. That was an
Right.
accident.
They,
Apparently, the legislatures didn't read the bill before the final bill before they signed it, and
right.
that provision was accidentally deleted. So my understanding is, from what I've heard, again, it's just all rumors that that's what they're working on, and I hope that that's the case. I hope they are working on that because it is an important provision to have in there that
It
provides
is. Yeah.
judicial discretion in order to sentence somebody a
Comes up
degree
all
lower, right? Like,
comes up all the
I
time.
mean, yeah. So, and that's a situation for anybody out there that's watching that says, well, I mean, obviously the legislature knew what they were doing and what they were trying to accomplish. And my response would be not necessarily. I mean, that they may have known what the ultimate goal was in terms of what they were trying to do, but they just missed the mark in terms of trying to do it. And that we see the situation with the recent enactment of mitigating factor 15 that was never, from my understanding, never the intention to remove the downward departure, but
Yeah.
mistakenly, the downward departure is now deleted from the statute. And now I think that they're working on trying to get it back in. And I hope that they're working on trying to get it back in because, again, it provides some additional judicial discretion in terms of sentencing.
Right, and it's like they clearly they didn't. They could. I can't imagine that they intended to do that by any means because the law they passed was specifically to add that mitigating factor. So why would you delete that section? Um, if the law is there, it was being passed to provide additional circumstances for the court to review for mitigation. It makes no sense. Um,
No, none whatsoever. And for those that aren't aware, with the mitigating factor 15, if that mitigating factor 15 is found, it then allows the court to sentence a degree lower. And in the
right,
new statute, it gives the guidelines for what that degree lower is. And normally we were only talking about downward departures from a first degree to a second degree or a second degree to a third degree. The statute didn't provide for further downward departures from a third degree to a fourth degree or fourth degree to a disorderly persons offense. But mitigating factor 15 does provide those guidelines. So now there's downward departures not just for first degrees and second degrees, but also for third degrees and fourth degrees. So maybe
right.
that
So
was the
they
original
expanded
intention to put that in,
that.
but for whatever reason, the way that the legislation was drafted, it just didn't make its way there.
Well, they deleted the whole paragraph instead of just
Yeah.
adding the set like what they wanted to add, which if you weren't like they I think what they meant what to do was to just replace that paragraph with the new one, but the new one doesn't have the other language in it, so
Yep.
but anyway, but I mean to the point, back to the point, and maybe circling back from the beginning of this is that at the end of the day, you get a lot of these different laws that are worded broadly to where there's so much discretion in charging. Still got to prove a case. That
Yeah.
ultimately is the greatest hurdle that needs to be overcome in any criminal case. Um, but the from charging to trial is where 99% of cases are resolved, and where most of the things happen. Um, so that discretion that you're giving the prosecutors to law school exam charges into any given case, that that's where you're gonna that's where you see the need to have a defense that pushes back just as hard, because again, they're always going to try to push the envelope. It's just the natural order of things, and it's the natural way that the adversarial process works. They're always going to push the envelope, and you need to have the other side push back, because otherwise the line won't be in the middle, right? The line's going to be over here then, because
Yeah.
that's where the line is when the defense doesn't do their job, And it might be easy to sit there and say, well, who cares about the defendants? But you know what? I have plenty of clients who call me up and they never thought they would have to talk to someone who practices criminal law, because they're in a situation where some, 12-second stupid decision, it has snowballed into felony charges that the prosecutor is saying, like, you know what, we're gonna push, we want the line over here, we're gonna push for that because we're gonna expansively interpret the statute, or we're gonna we're gonna push for detention for this guy who doesn't have a record, because he fell through the threshold of the door, and we can now charge a first degree crime instead of a misdemeanor. So that.
Yeah, and I see it happen all the time as well, from the clients that we represent. And, people that are nurses or union workers or engineers or
Yeah.
people that have never been in contact with the criminal justice system, and then, end up represented by our office. And again, we only represent indigent people, but most people are just a life event away from that. If you're a nurse and you lose your job and you have your nursing license temporarily suspended, you can't work, you may then qualify for a public defender, and you may have to have that public defender, or if you are able to still have funds to hire an attorney, fight for you, and ultimately to get you back to where you should be, whether it's getting the charges dismissed or getting into PTI. But yeah, we run into people all the time that have never had charges brought against them, have never contemplated on being involved in the criminal justice system, but unfortunately find themselves here for one reason or another.
Yeah. Yeah. No, it's a rude awakening too. Especially when you have the client who's never been involved in the criminal justice process. I think a lot of times, like, it's a rude awakening because they have this idea, like, wow, nothing unfair happens in the criminal justice process works perfectly. Like, there's no, like, but realistically, I have to explain to people sometimes when they're like, how can I be charged with this? Like, how can this happen? Like, and I told them, I was like, it's really easy to get charged with with a charge. Like, really,
Yeah.
you just need one person to say that you did something. Like, if I went down to the police department and I saw Alex Settle, like, threaten to kill me, we were on the phone, he threatened to kill me, I want to file terroristic threat charges. They'd be like, here's the
They would,
form,
yeah,
here's the probable cause,
100%. They would
fill
file
it
it.
out, and then I'd fill it out. He would get charged. He would get charged with a felony, right? Excuse me. It would go to the prosecutor's office for review. Okay. Now, if things are done correctly, most prosecutors would look at that and they'd be like, ooh, yeah, this belongs in municipal court. They'd send it back down to municipal court as a harassment misdemeanor. And then Alex would be stuck coming to court and dealing with my charge in municipal court. And if I told the municipal prosecutor it totally happened, I want to go to trial, he would be stuck having a trial over this for a judge to decide whether he said that to me over the phone, where there's no other witnesses and no other evidence that it happened. And that can easily happen to someone. Like, you could have a narcissistic person that you're dealing with in your life, and they end up utilizing the judiciary or the criminal justice process to leverage against you the situation. And like, it sucks. It sucks. But I have to tell clients sometimes, like, yeah, like, unfortunately, again, probable cause, well-grounded suspicion. Someone says something happened, well-grounded suspicion, charged. Like that's what it's
Yeah,
it's been
and it's
eroded
true.
away to is if one person says something happened, well-grounded suspicion, like approve the charge, and then like they'll figure it out in court. Like forget about the
We see it. We see it
yeah
happen all the time, right?
yeah
Right. And like for those, I'll give you two examples going off of, I'll come back to what you said, when the state does their job and does the job they're supposed to do. But for anybody that watches Netflix, there's a good series called Worst Ex Ever. And in some of the episodes, that's basically what the ex that had abused them did. They went and reported false charges and they get incarcerated as a result of that. I mean,
yeah.
it can happen to anybody. And
And
going
like
off of what you said before in terms of like the police doing their job and the state doing their job, it's very easy for somebody to make up a complaint against someone, right? Like I had a case that I had handled years ago where the ex had said that my client had gone into where they were working and had pulled out a gun and had threatened to kill them, right? So she went to the police department, she reports it. You would think that the police would do their job and they would go to that restaurant and pull security footage because there was security footage at that restaurant, or maybe go to the restaurant and interview witnesses, interview the manager, interview anybody that was eating there at the time. No, 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 they didn't. They just put it on a warrant. And then he got arrested several weeks later. And fortunately, we were able to get him released from jail while the whole case played out. And luckily, there was a prior incident where she had made up a false claim against him as well, that he had assaulted her, and he
I remember
actually got it
the
on
case.
video. You remember this case? He
I
actually got it on
remember yeah,
video.
the case me and
And
Alex.
and he recorded her. He recorded her smashing herself in the face with a flashlight and then saying, "I'm going to call the cops now." And she did, and she reported him. And it was only because of that video that that case got dismissed. And then I was able to detain that video, provide that video, and then this case got dismissed. But that's how easy it is for somebody to make up charges against someone. And if you have a police department that doesn't do their job and they don't follow through on the things that they follow through, you have this person that gets charged and unfortunately runs the risk of getting convicted of a crime that they never actually committed.
and
It's
and
it's
you know,
it's terrible.
to highlight Alex's story, because this is a true story, and this is I was the prosecutor. Uh, from the other perspective on it, when I was the prosecutor, is I was in the role where I didn't handle cases when they were first charged. Like I didn't decide what got indicted, and indictment means bringing a case to the grand jury, which is a panel of like 15, 20 random people from the community who decide from a like 5-minute presentation from maybe a police officer who says, yeah, so and so came in the police department and said that her boyfriend came to the restaurant and pulled a gun on her. And then the grand jury 99.99% of the time says, okay, indict it and send it to court and they'll figure it out there, because they're just there to decide whether there's a well-grounded suspicion. So that's indictment. So I didn't decide what cases got indicted. I handled them after they were indicted. So to put it into perspective for the audience who doesn't really know, how this works exactly, a gun charge in New Jersey it's a difficult charge to resolve, because there's mandatory penalties in terms of prison time. So like you have to get approval from the higher ups to waive certain mandatory penalties. And in a case like that, there's no gun recovered, right? It's just an allegation. Hey, this guy came to the restaurant and he pulled a gun out, and I saw him do it. They didn't get the video. They did it like by the time I get the file, it's months later. So by the time I get the file, like any investigative leads that might have existed at the time are gone, and there's little that I can do to investigate them. But I'm stuck with a case now that has mandatory penalties, and realistically, I don't recall, Alex. I think we negotiated down to a certain point that it was a pretty low offer, but he insisted that he didn't want to.
You
He
don't want
insisted
it. Yeah.
right. So we
Yeah.
negotiated down, and I think I got approval to come down very low, because I knew it was like it was a he said she said situation, very difficult to prove. And then I was supplied the video of the other party in a separate incident, literally just smacking her face with, I think it was was it a flat? You said it was a flashlight. I
Yeah,
can't
it's one
remember.
of those big, heavy duty, like industrial flashlights.
Yeah, she's just smacking her face with it in this video, and then she drops it and she picks her phone up and says, "Now I'm calling the police." And I'm like, "Wow, Now I'm going to go ask for a dismissal. And
Yeah.
thankfully, they allowed me to dismiss that, because at that I was like, what are we doing at this point? It's a he said she said, and this woman has a prior false accusation essentially. So we resolved it that way. That was a difficult conversation over the phone with the victim, because I always, I never did anything like that unless I consulted the victim, and I had to tell her, like, hey, I don't think we can prove this case. I do have a video of XYZ,
Yeah.
and I think that unfortunately that's going to make it impossible to prove this allegation. Um, and she was understanding, disappointed but understanding. But yeah. How often do you get the video? Like, how often do you actually get that?
I know.
I tell clients all the time, it's like criminal law and jury trials. It's not about what happened. It's about what you can prove. Like, you could have
Yeah.
the most toxic human being in the world who has been like a narcissist, liar, everything else. If you don't have any way of documenting that in front of a jury, to where you have like text or physical exhibits or videos or something, you're basically just the jury's going to just see this person for what, an hour when he's on the stand, and they're going to be like, well, like, they're gonna judge everything based on this 1 hour of this person. Well, yeah, maybe he is a narcissist, maybe he is a sociopath, but unless that can come out for in that hour, if they keep it together for that hour and say, hey, so and so did this to me, guess what? Like, you don't get the jury doesn't get to see the whole situation in a vacuum where they see it from beginning to end. They see this little tunnel vision version of what happened, and you get in as much as you can in their defense. But if they don't have anything to document what the prior credibility issues, and you're not going to be able to do it. So I have to have
Yeah.
that difficult conversation. It's like, yeah, you like, at the end of the day, it is that easy to charge someone, and then you may be in a situation where, like, hey, look, they got pictures of that woman who hit her. If he didn't have a video of her hitting herself with the flashlight, right, and then the police come and they see red marks on her face, and she says that he hit her, he's getting charged. Like,
Yeah.
he's getting charged. And then the prosecutor's going to get that. Well, look, I have pictures of injuries. Like, I mean, this seems like a well documented case. And it's like, well, he says that he hit herself in the face with a flashlight. Bullshit. That didn't happen. Like, that's like, he's just making that up. But that's if you don't have the video, right? And how many times did that happen? And that happens way more often than
No,
that
yeah.
happens
And
way
then
more
you
often.
have to have a defense attorney that's willing to dig into it, that's willing to look at the injuries where you say you have somebody that says, oh, he hit me, or he caused this injury to me when it happened 10 minutes ago, and there's a huge bruise. And what we know is, like, a bruise doesn't occur within 10 minutes. Like, that didn't just happen. But
Yeah.
it comes down to a defense attorney being able to attack those things and being able to really fight for you. Being able to identify any of the inconsistencies in the case, or depending on where it occurred, maybe the defense attorney submits subpoenas and tries to get video evidence. I think that's what is all the more important reasons for why we do what we do, and it's important to have an attorney that's really willing to fight for you. Because unfortunately, if you didn't, you might have some serious charges that are hanging over your head, and you could potentially have an attorney that's saying, this is a good deal. They're offering you probation on this case, but if you didn't do it, is it really actually a good deal? Especially if you have
Yeah.
an attorney that's able
It's
to point out the inconsistencies and, really challenge the evidence and push the envelope.
Yeah, I mean, it's a difficult decision only the client can make. I mean, I always try to
Yeah.
make sure they have all the information to make an informed decision, because that's at the core of our job. That is our job, is to make sure that the client can make an informed decision one way or the other. But unfortunately, in most criminal cases, that informed decision looks like take the easy way out and no jail, or less jail, or limited jail, or go to trial, take a chance, and if you lose, a lot of prison, you know? and so
Yeah, and that's what we have to tell our clients. Like our job is to negotiate this offer as low as we possibly can, and we'll do that based on identifying weaknesses in the evidence and presenting mitigating information. And then once we get that down to where it's not going to go any lower, it's a choice that only you can make. You know,
right,
you have to decide
right,
whether you're willing to take it or whether you're willing to go to trial, because what I explain to clients is you're the only one that has to live with the consequences. If you accept an offer for state prison and it's 3 years, like you have to do that 3 years. I can't make that decision for you. And if you'd make the decision to go to trial and it's more than 3 years because you get convicted, I can't make that decision for you. That's an informed
yeah.
decision that you have to make. The only thing I can do is do everything as I can in terms of being an advocate on your behalf and trying to get that resolution down as low as possible. And then if we can, if it's an offer you're willing to take, you know, that's your decision. And if it's not, I'll do everything I possibly can to fight for you at trial.
Well, Alex, I think we hit the end of our hour here. Any final remarks?
No, I just appreciate you having me on. You know, look forward to being back again someday. It was a good discussion.
Thanks for coming on, Alex. I'm sure I'll see you in court next week sometime.
All right, sounds good. I'll see you, Lou.
All right, take
All
care.
right.